This is Syndication Attorney Field Notes. I'm Tilden Moschetti, a syndication attorney, and today's field note is about 3 documents in a Regulation D private placement: the subscription agreement, the private placement memorandum, and the operating agreement. Here's the scenario. A sponsor tells me an investor just signed everything and wired the money, so they're in the deal. And I have to say, not quite yet. That gap right there is today's field note. So let me give you the direct answer first. These 3 documents are not 3 onboarding forms in the same e-sign packet. They do 3 different jobs. And once you see the jobs, a lot of common mistakes stop making sense. Here's the simplest way I frame it. The PPM is the shield. The operating agreement is the engine, and the subscription agreement is the gatekeeper. The PPM discloses the deal. It tells the investor what they're buying and what the risks are. The operating agreement governs the entity. It's the rule book for how the fund or the syndication actually runs. And the subscription agreement binds the investor to the transaction and to that operating agreement. It's also the point where you, the sponsor, get to accept or reject the investment. Disclosure, governance, admission, 3 jobs. Now, why do smart sponsors still get this wrong? Because the software makes it feel like opening a web account. You click through a few screens, you check a box, you e-sign, and it's done. That smooth workflow quietly tells you that joining a private placement is like signing up for an app. It isn't. The investor is buying a security in a transaction governed by federal law. So the convenience can hide how much sequence and consistency actually matter. Let me clear up who signs what, because this surprises people. The investor doesn't sign the PPM. They acknowledge receipt of it. The PPM is a disclosure document, not the contract that governs the entity. And in these fund structures, the investor usually doesn't manually sign the operating agreement either. You're not chasing 100 investors for wet signatures on a 60-page governance document. Instead, the investor is bound to the operating agreement through the subscription agreement. The subscription agreement says, in effect, by signing this, you agree to be bound by the terms of the operating agreement. So the subscription agreement is the bridge. It carries the investor's signature over to the document they never directly signed. That's why the subscription agreement is more than intake. It's where the investor makes their representations, and it's the document you accept or reject. Here's a quick example that shows why the roles matter. Say a sponsor has one demanding investor, and to close them, the sponsor writes a special preferred return right into that investor's subscription agreement. But the PPM and the operating agreement still describe the standard waterfall for everyone. Now you've got a gatekeeper that promises something the engine doesn't support. The subscription agreement can't quietly rewrite the operating agreement. That mismatch can create claims from the other investors who took the standard terms, and it can invite scrutiny. Custom terms belong inside the governance structure, done the right way, not slipped into one joining document. Now, a few things not to assume. Don't assume that a signed subscription agreement and a cleared wire mean the investor is in. At that point, they've made an offer to invest. You still review it, you confirm the funds arrived, and you countersign. The investor is admitted when you accept and countersign, not the moment the money hits the account. That review step protects you. Don't assume a checked accreditation box is enough in a Rule 506C offering. In a 506C deal, you have to take reasonable steps to actually verify accredited status using outside evidence. The self-representation in the subscription agreement is part of the picture. It isn't the whole picture. And don't assume wet ink is safer. It usually isn't. Electronic signatures are fully valid here. In fact, sending the PPM, the operating agreement, and the subscription agreement out in one digital e-signature envelope can be stronger proof because it shows the investor had the disclosures before they signed. Scattered paper pages are harder to timestamp and harder to prove delivery on. So here's the takeaway for the notebook. Don't think of these as three independent forms. Think of them as one Regulation D capital raising machine, shield, engine, gatekeeper. The documents should agree with each other, they should go out in the right sequence, and they should all describe the same deal. When disclosure, governance, and admission line up, the offering record holds together. The longer written version is in the show notes. This has been Syndication Attorney Field Notes. I'm Tilden Moschetti.